I am witnessing what may prove to be the most sophisticated demonstration of asymmetric legal warfare in modern international relations, as Russia's central bank filed a single lawsuit on December 12, 2025, seeking 18.2 trillion rubles in damages from Euroclear in Moscow's arbitration court, effectively weaponizing the international legal system to neutralize the European Union's elaborate four-year scheme to confiscate $210 billion in frozen Russian sovereign assets for Ukraine funding, transforming Putin's apparent disadvantage into devastating strategic leverage that has paralyzed European decision-making and exposed the fundamental vulnerabilities of Western financial architecture. This legal maneuver represents far more than routine litigation or diplomatic posturing, constituting instead a masterclass in how authoritarian regimes can exploit the very legal frameworks that democratic systems depend upon for legitimacy, using the West's commitment to rule of law as a weapon against Western interests, while simultaneously demonstrating that economic warfare in the 21st century operates through courtrooms and legal precedents rather than traditional military or diplomatic channels. I analyze this moment as representing the emergence of a new form of state-level conflict where legal systems become battlegrounds and court jurisdictions serve as strategic assets, enabling smaller powers to neutralize the economic advantages of larger coalitions through patient, methodical exploitation of legal vulnerabilities that democratic institutions create through their own commitment to due process and international law compliance. The timing and precision of Russia's legal assault reveals sophisticated strategic planning that has been years in development, waiting for the optimal moment when European leaders had committed themselves so deeply to the asset seizure plan that retreat would represent political humiliation, while advance would require accepting potentially catastrophic legal and financial risks that could fundamentally undermine the European Union's credibility as a reliable custodian of international reserves. When I examine the mechanics of Russia's legal strategy, the brilliance becomes apparent through its exploitation of multiple simultaneous pressure points designed to force European decision-makers into impossible positions where every available option carries devastating consequences for European financial institutions, political cohesion, and international standing that democratic governments cannot easily absorb without triggering internal political crises. The lawsuit itself targets Euroclear, the Brussels-based central securities depository that holds approximately 185 billion euros of the frozen Russian assets, representing roughly 88% of all Russian central bank reserves immobilized across European Union territory, making Euroclear the single most critical node in the entire asset seizure architecture that European leaders have constructed since February 2022, when Western sanctions were first imposed following Russia's invasion of Ukraine. Euroclear operates as the backbone of European post-trade financial infrastructure, processing over $42.5 trillion in custodial assets and serving as the primary settlement mechanism for pension funds, central banks, and commercial banks throughout the European Union, meaning that any successful legal challenge to its operations would create cascading disruptions throughout European financial markets that extend far beyond the immediate question of Russian asset management. The Russian central bank's claim for 18.2 trillion rubles, equivalent to approximately $230 billion at current exchange rates, encompasses not only the frozen funds themselves, but also lost profits, management fees, and opportunity costs that Russia calculates as resulting from Euroclear's unlawful actions in preventing Moscow from managing its own sovereign reserves, creating a comprehensive damages framework that potentially exceeds the total value of assets under dispute. Russia's strategic calculation appears designed to transform Euroclear from a neutral financial institution into a geopolitical liability for the European Union, forcing Brussels to choose between abandoning its Ukrainian funding plans or accepting responsibility for potential legal judgments that could bankrupt one of Europe's most critical financial infrastructure providers, while establishing precedents that undermine the security of sovereign asset custody globally. The lawsuit's filing in Moscow's arbitration court ensures that Russian judges will evaluate European financial institutions according to Russian legal standards and interpretations of international law, creating jurisdictional asymmetry where European defendants must operate within Russian legal frameworks, while their own court systems lack reciprocal authority over Russian state entities or assets within Russian territory. This jurisdictional manipulation represents a fundamental exploitation of sovereignty principles that democratic legal systems respect, but authoritarian regimes manipulate, enabling Russia to weaponize legal pluralism against opponents who remain constrained by their own commitments to international law and due process protections that Russian courts are not obligated to reciprocate or recognize. The preliminary hearing scheduled for January 16, 2026, establishes a timeline that coincides perfectly with European Union budget planning cycles and Ukrainian funding requirements, creating temporal pressure that forces European leaders to make decisions about asset seizure before they can fully understand the legal consequences or develop adequate defensive strategies against Russian retaliation. Belgium's resistance to the EU asset seizure plan has intensified dramatically since Russia's lawsuit was filed, with Prime Minister Bart de Wever explicitly stating that European guarantees remain insufficient and warning that confiscation could trigger cascading failures throughout Euroclear's operations that would undermine confidence in European financial markets while violating fundamental principles of international law that Belgium cannot accept responsibility for breaching. The Belgian position reflects recognition that Euroclear's global credibility depends on its perceived neutrality and reliability as a custodian of international assets, characteristics that would be permanently compromised if the institution becomes viewed as an instrument of European foreign policy rather than a neutral financial intermediary operating according to predictable legal standards that all participants can trust, regardless of political circumstances. Hungary and Slovakia have seized upon Russia's legal challenge as validation for their opposition to asset seizure, with Hungarian Prime Minister Viktor Orban denouncing the European Commission's emergency clause invocation as systematically raping European law and promising to pursue all available remedies to restore what he characterizes as lawful order against Brussels' authoritarian overreach. Italy, Bulgaria, Malta, and the Czech Republic have joined Belgium in opposing the reparations loan scheme, creating a blocking minority that prevents the qualified majority voting that would be necessary to implement asset seizure, despite the European Commission's use of Article 122 emergency powers to bypass normal consensus requirements and indefinitely freeze Russian assets without periodic renewal votes. This internal European resistance demonstrates how Russia's legal warfare strategy succeeds not through direct confrontation with European power, but through amplification of existing divisions within European Union decision-making structures that democratic governance creates through its commitment to consultation, consensus building, and legal constraint on executive authority. The European Commission's three-tiered defense mechanism, designed to protect Belgium and Euroclear from potential Russian retaliation, reveals the extent to which Brussels recognizes the legitimacy and potential effectiveness of Russia's legal threats, while attempting to maintain political support for asset seizure plans that increasingly appear legally indefensible and financially catastrophic for participating institutions. Under this defensive framework, European institutions would be permitted to offset losses from Russian legal judgments against other Russian assets held within European jurisdiction. But this mechanism itself acknowledges that European courts and financial institutions cannot simply ignore Russian legal decisions without creating reciprocal vulnerabilities that undermine the international legal cooperation that European financial institutions depend upon for global operations. The proposed offset mechanism also reveals European recognition that Russia possesses sufficient assets within European jurisdiction to execute substantial retaliation against European financial institutions, making the legal warfare bidirectional rather than simply defensive, and ensuring that escalation would harm European interests regardless of the ultimate resolution of underlying legal disputes about asset ownership and custody obligations. Russia's promise to pursue all available legal and other mechanisms without further notice creates strategic ambiguity about the scope and timing of potential retaliation, forcing European institutions to prepare for multiple simultaneous legal challenges across different jurisdictions while maintaining normal operations that depend on predictable legal environments and stable custody relationships with international clients. The other mechanisms terminology suggests that Russia's response will extend beyond purely legal remedies to encompass economic, diplomatic, and potentially cyber warfare tools that authoritarian regimes can deploy more rapidly and with fewer constraints than democratic governments, creating asymmetric advantages in escalation management that favor the more ruthless and less legally constrained participant in the conflict. European Union officials' dismissal of Russia's lawsuit as speculative and groundless contradicts their simultaneous development of elaborate defensive mechanisms designed to protect European institutions from exactly the kind of legal challenges they publicly characterize as frivolous, revealing cognitive dissonance that suggests European leaders understand the seriousness of Russia's legal threats while maintaining public positions that minimize their significance for domestic political consumption. This contradiction between public dismissal and private preparation indicates that European leaders recognize they have created legal vulnerabilities that Russia can exploit effectively, but cannot acknowledge this recognition without undermining political support for policies that have been presented as legally sound and strategically necessary responses to Russian aggression that require continued commitment despite emerging complications. The European Commission's invocation of Article 122 emergency powers to indefinitely freeze Russian assets represents an unprecedented expansion of emergency authority that Hungarian leaders correctly identify as fundamentally inconsistent with European Union legal principles, creating constitutional precedents that future European leaders could invoke to bypass democratic oversight during other perceived emergencies that may have less compelling justifications. This constitutional overreach demonstrates how external pressure from Russian legal warfare forces European institutions to abandon their own legal principles in pursuit of geopolitical objectives, creating the kind of institutional degradation that authoritarian opponents seek to provoke through patient, methodical exploitation of democratic vulnerabilities that democratic systems cannot easily address without compromising their own foundational commitments. The failure of European consensus on asset seizure, despite unanimous agreement on the principle of supporting Ukraine, reveals how Russian legal warfare succeeds by forcing democratic allies to choose between competing values and obligations that authoritarian opponents deliberately structure to be irreconcilable, creating decision paralysis that prevents effective collective action against authoritarian aggression. When I analyze the global implications of this legal warfare model, the strategic significance extends far beyond European-Russian relations to encompass fundamental questions about the security and reliability of international financial custody arrangements that central banks, sovereign wealth funds, and other major institutional investors depend upon for reserve management and cross-border transaction settlement. China, Saudi Arabia, the United Arab Emirates, and other major holders of foreign reserves are undoubtedly studying Russia's legal tactics as potential templates for protecting their own assets from political weaponization by Western governments, while simultaneously reassessing the risks associated with holding substantial reserves in jurisdictions where political considerations can override traditional custody protections and legal immunities. The precedent being established suggests that sovereign asset custody is no longer protected by the legal and institutional frameworks that have governed international finance since the Bretton Woods system, creating incentives for major reserve holders to diversify away from Western financial institutions and toward alternative custody arrangements that provide stronger protection against political appropriation during geopolitical conflicts. This diversification process, already visible in central bank gold purchases and alternative payment system development, will likely accelerate as the Russia-Europe legal warfare demonstrates that even the most sophisticated Western financial institutions cannot guarantee the security of client assets when those institutions become instruments of government policy rather than neutral service providers operating according to predictable legal standards. Russian success in weaponizing international legal systems also provides a blueprint for other authoritarian regimes to exploit democratic commitments to rule of law and due process, potentially creating cascading legal challenges across multiple jurisdictions whenever Western governments attempt to impose economic sanctions or freeze assets belonging to authoritarian opponents who possess sufficient legal sophistication and patience to mount systematic legal resistance. The technical complexity of Russia's legal strategy, encompassing multiple types of damages calculations and utilizing various international law doctrines regarding sovereign immunity and state responsibility, suggests that authoritarian regimes have invested substantially in developing legal warfare capabilities that democratic governments have not anticipated or prepared adequate defenses against through their own legal and institutional planning. European inability to resolve the asset seizure question, despite years of preparation and extensive legal analysis, indicates that democratic governments may be systematically disadvantaged in legal warfare against authoritarian opponents who can manipulate multiple legal systems simultaneously, while democratic governments remain constrained by their own legal obligations and institutional limitations that prevent comparable legal manipulation. The Trump administration's 28-point plan proposing distribution of frozen Russian assets among Ukraine, Russia, and the United States represents American recognition that European asset seizure plans have failed and alternative arrangements must be developed that bypass European institutional paralysis, potentially creating transatlantic divisions about Russian asset management that further complicate collective Western responses to Russian aggression. American pressure for European asset seizure simultaneously weakens European political cohesion while providing Russian legal warfare with additional legitimacy as a defensive response to American financial coercion, creating strategic contradictions within Western alliance management that Russian opponents can exploit to undermine collective action and alliance solidarity. The convergence of multiple crisis elements, Belgian resistance, Hungarian opposition, Italian concerns, Russian legal threats, American pressure, and Ukrainian funding requirements, creates a perfect storm of competing pressures that European decision-making institutions cannot resolve through normal consensus mechanisms, forcing either constitutional overreach or strategic retreat that damages European credibility and institutional authority. When I project forward from current trajectories, I see European leaders trapped between impossible alternatives where asset seizure creates potentially catastrophic legal vulnerabilities, while abandoning asset seizure represents political humiliation and strategic defeat that undermines European credibility as a reliable ally and effective geopolitical actor capable of sustaining long-term commitments to partners under pressure. Russia's legal warfare strategy succeeds regardless of ultimate court decisions because the litigation process itself creates sufficient uncertainty and institutional stress to prevent effective European action while demonstrating to other potential opponents that patient legal resistance can neutralize Western economic advantages through exploitation of democratic legal vulnerabilities that authoritarian regimes do not share. The January 16, 2026 preliminary hearing will likely be followed by years of additional litigation across multiple jurisdictions as Russia systematically challenges every aspect of European asset management decisions, creating sustained legal pressure that European institutions cannot easily resolve while maintaining normal operations that depend on legal certainty and predictable regulatory environments. European financial institutions will be forced to allocate substantial resources to legal defense against Russian challenges, while simultaneously managing normal client relationships that depend on confidence in institutional stability and reliability, creating operational stress that affects European financial competitiveness relative to institutions operating in jurisdictions that provide stronger protection against political appropriation of client assets. This legal warfare model will likely be adopted by other authoritarian regimes facing Western economic pressure, creating multiple simultaneous legal challenges across different jurisdictions that democratic governments cannot address through normal diplomatic or legal channels without fundamentally altering their own legal systems and institutional commitments in ways that compromise democratic governance principles. As I conclude this analysis, the profound irony becomes apparent. Europe's attempt to use frozen Russian assets to demonstrate Western resolve and capability has instead revealed fundamental Western vulnerabilities that authoritarian opponents can exploit through patient legal warfare that turns democratic institutions against themselves while creating strategic advantages for opponents who face no comparable institutional constraints or legal obligations. Russia's legal gambit thus represents not merely tactical cleverness, but strategic insight into the structural weaknesses of democratic systems when confronted by opponents who can weaponize legal pluralism and jurisdictional complexity against institutions that remain constrained by their own commitments to rule of law and international legal cooperation. The ultimate lesson extends beyond Russian-European relations to encompass broader questions about democratic resilience in an international system where legal warfare enables authoritarian regimes to exploit the very institutional characteristics that democratic societies consider essential for legitimate governance, creating systematic disadvantages that may prove decisive in long-term geopolitical competition. Future historians may identify Russia's Euroclear lawsuit as a turning point when authoritarian legal warfare demonstrated its capacity to neutralize democratic economic advantages through systematic exploitation of legal vulnerabilities that democratic systems cannot eliminate without abandoning the institutional commitments that define democratic governance itself.